If you are a green card holder, a U.S. citizen, or someone waiting for immigration approval, you may have seen alerts and headlines recently talking about confirmed changes to green cards that could impact you this year. I understand that when you see words like alert and changes, your mind immediately goes to worry. You might be asking yourself if your green card is at risk, if new rules will affect your status, or if you need to take immediate action. Take a deep breath. My goal today is not to scare you. My goal is to explain calmly and clearly what is actually happening, who is truly affected, and what you need to know to stay informed without feeling overwhelmed. My name is Sarah, and I have been covering U.S. immigration news for years, always with one purpose in mind: to bring you the truth in a way that helps you feel more confident, not more afraid. Today, we are going to walk through the confirmed changes step by step, separate fact from rumor, and make sure you understand exactly where you stand. No hype, no panic, just honest information delivered with care. Before we begin, I want to make something very clear. I am not an immigration attorney. I am not a government official. I am not here to give you legal advice. What I share with you today is educational information based on publicly available updates from official sources. If you have a specific legal question or a complicated situation, you should always consult with a qualified immigration lawyer who can review your individual case. My role is simply to explain what is happening in a way that is easy to understand, especially for those of you who may find official language confusing or overwhelming. I want to be a trusted source of clarity, not a replacement for professional legal guidance. With that said, let's get started. So what exactly are these confirmed changes to green cards that people are talking about? Let's begin by understanding what is actually happening. In recent months, the United States Citizenship and Immigration Services, known as USCIS, has announced several policy updates and procedural adjustments that affect green card holders and green card applicants. These are not sudden overnight changes that happened without warning. These are updates that have been in development for some time, and they are part of the normal process of how immigration policy evolves. Some of these changes involve how USCIS processes applications, how certain forms are filled out, what documents are required, and how interviews are conducted. Other changes involve fee adjustments, processing times, and enforcement priorities. It is important to understand that when we say changes, we are not talking about the elimination of green cards or mass revocations of legal status. We are talking about adjustments to procedures and policies that may affect how things are done, not whether you are allowed to stay in the United States if you have followed the rules. Let me be very specific about who these changes apply to. First, some of the changes apply to people who are currently applying for a green card. If you have submitted an application for adjustment of status, or if you are going through consular processing abroad, some of the procedural updates may apply to you. This could mean slightly different forms, additional documentation requirements, or changes in how interviews are scheduled. For most people, these changes are administrative in nature. They do not mean your application will be denied. They simply mean the process may look a little different than it did a year or two ago. Second, some changes apply to green card holders who are renewing their cards. If your green card is expiring and you need to file Form I-90 to renew it, there may be updated fees or new instructions on how to submit your application. Again, this is routine. Green cards expire every 10 years, and the renewal process is something millions of people go through without issue. Third, some changes involve how USCIS handles cases where there are concerns about fraud, criminal activity, or violations of immigration law. This is not new. USCIS has always had the authority to investigate cases where there is credible evidence of wrongdoing. What has changed is that enforcement priorities may be shifting, meaning certain types of cases may receive more scrutiny. But let me be very clear about this. If you obtained your green card honestly, if you have not committed fraud, and if you have been following the conditions of your status. These enforcement priorities are not aimed at you. Now let me tell you who these changes do not apply to. If you are a green card holder who has been living in the United States lawfully, paying your taxes, staying out of trouble, and meeting the basic requirements of your status, the vast majority of these changes will not affect your daily life. You do not need to worry that your green card will be taken away simply because policies are being updated. The process of removing someone's green card, which is called deportation or removal, is a legal process that requires evidence, hearings, and due process. It does not happen randomly, and it does not happen just because there is a policy change. If you are a naturalized U.S. citizen, these green card changes do not apply to you at all. Once you become a citizen, your status is not dependent on green card rules. Your citizenship is protected by the Constitution, and it cannot be taken away except in extremely rare cases involving fraud in the naturalization process itself, and even then, it requires a lengthy legal process. If you are a U.S. citizen by birth, these changes have absolutely no impact on you. I mention this because I know many of you watch these videos, not just for yourselves, but to understand what your family members, friends, or loved ones may be experiencing. Let's talk about some of the common myths that are circulating right now, because I know misinformation spreads quickly, especially on social media. One myth I have seen is that green card holders will now be deported if they leave the country for more than 6 months. This is not a new rule. It has always been the case that if you are a green card holder and you leave the United States for an extended period, especially more than 6 months to a year, you risk being seen as having abandoned your permanent residence. This is not a change for this year. This has been part of immigration law for decades. If you are planning to travel outside the United States for an extended period, you should apply for a re-entry permit before you leave. That is the proper way to protect your status. Another myth is that all green card holders will now be required to reapply or go through additional interviews. This is not true. The only people who need to renew their green cards are those whose cards are expiring, which happens every 10 years, as I mentioned earlier. You do not need to reapply for your green card just because policies are being updated. A third myth is that dual citizenship or owning property abroad will automatically get your green card revoked. This is false. Many green card holders maintain ties to their home countries, own homes or businesses there, and even hold dual citizenship where permitted. None of this automatically disqualifies you from holding a green card. What matters is that you maintain your primary residence in the United States and that you intend to live here permanently. As long as you are meeting those basic requirements, you are fine. Let me now address the difference between rare situations and everyday life, because I think this is where a lot of confusion happens. Yes, there are rare situations where a green card can be revoked. These situations involve serious issues, like committing certain crimes, engaging in fraud, providing false information on your application, or being involved in activities that threaten national security. These are not common situations. These are extreme cases that involve significant evidence and legal proceedings. For the vast majority of green card holders, these situations will never apply. Your everyday life, going to work, raising your family, paying your bills, traveling occasionally, participating in your community, none of this puts you at risk. The immigration system is designed to allow millions of people to live and work in the United States legally, and it does so successfully every single day. The headlines that focus on deportations and enforcement actions are often highlighting the rare exceptions, not the normal experience of most immigrants. I want to take a moment here to explain some important distinctions, because understanding these differences will help you feel more secure. First, let's talk about the difference between a mistake and intentional fraud. If you made an honest mistake on your application, perhaps you forgot to list a minor traffic ticket from years ago, or you misunderstood a question on the form. This is very different from intentionally lying or hiding information. USCIS understands that applications are long and complicated, and minor errors happen. If they have questions about something on your application, they will usually give you a chance to explain or provide additional information. Intentional fraud, on the other hand, involves deliberately providing false information with the intent to deceive. This is much more serious, but it also requires proof of intent. It is not assumed. Second, let's talk about the difference between delays and denials. A delay means your application is taking longer to process. A denial means your application has been rejected. Right now, USCIS is experiencing significant delays across almost all types of applications. This is frustrating, and I understand how stressful it is to wait, but a delay does not mean something is wrong with your case. It often just means the system is backlogged. A denial, when it happens, always comes with a written explanation and information about your right to appeal. You are never denied without being told why. Let me also clarify the difference between dual citizenship and loyalty issues. Some people worry that if they hold citizenship in another country, this will be seen as a loyalty problem by U.S. immigration authorities. In most cases, this is not true. The United States allows dual citizenship in many situations, and simply holding another passport does not mean you are disloyal to the United States. What immigration law cares about is whether you are following the rules of your immigration status. If you are a green card holder, you need to maintain your permanent residence in the U.S. If you become a U.S. citizen, you take an oath of allegiance, but this does not require you to give up your other citizenship in most cases. The situations where dual citizenship might create a problem are extremely rare, and usually involve very specific circumstances, like holding a government position in another country or serving in a foreign military. For the vast majority of people, dual citizenship is perfectly legal and acceptable. Now let's move into some practical guidance, because I know many of you are wondering what you should actually do with this information. First, if you are a green card holder and your card is expiring within the next 6 months, go ahead and start the renewal process by filing Form I-90. Do not wait until the last minute. Processing times are long right now, and you want to make sure you have proof of your status while your renewal is pending. When you file for renewal, USCIS will send you a receipt notice, and that receipt notice extends your green card for a certain period while they process your application. Keep that receipt notice safe. You may need it when traveling or proving your status to employers. Second, if you are planning to travel outside the United States for more than 6 months, apply for a re-entry permit before you leave. This is Form I-131, and it shows USCIS that you intend to return and maintain your permanent residence. It protects you from being seen as having abandoned your status. Third, make sure your address is always up to date with USCIS. Whenever you move, you are required to file Form AR-11 within 10 days. This is important because USCIS sends important notices by mail, and if they send something to an old address, you might miss a deadline or an interview notice. What should you not panic about? You should not panic if you have been waiting a long time for your application to be processed. Long wait times are unfortunately normal right now. USCIS is dealing with a massive backlog, and processing times for many applications are measured in months or even years. This does not mean your case is in trouble. It just means the system is slow. You should not panic if you receive a request for evidence, known as an RFE. An RFE simply means USCIS needs more information or documentation to make a decision on your case. It is not a denial. It is an opportunity for you to provide what they need. Read the RFE carefully, provide exactly what is requested, and submit it before the deadline. If you are unsure how to respond, that is a good time to consult with an immigration attorney. You should not panic if you see news stories about immigration enforcement or deportations. Remember that enforcement actions target specific situations, usually involving criminal activity or fraud. If you have been following the rules, these stories are not about you. How can you stay prepared? Keep copies of all your immigration documents in a safe place. This includes your green card, your passport, any approval notices from USCIS, your tax returns, and proof of where you have been living. If you ever need to prove your status or your history, having organized documents will make everything easier. If you have any interaction with law enforcement, even something minor like a traffic stop, be polite and cooperative and know your rights. You have the right to remain silent, and you have the right to speak with an attorney. You do not have to answer questions about your immigration status to local police in most situations, but you should always be respectful. If you are ever served with a notice to appear in immigration court, do not ignore it. This is extremely important. If you miss your court date, a judge can order you deported in your absence. If you receive such a notice, contact an immigration attorney immediately. When is professional help useful? If you have any kind of criminal charge, even a minor one, talk to both a criminal attorney and an immigration attorney. Some criminal convictions can affect your immigration status, so you want to make sure both aspects are handled correctly. If you receive a notice of intent to deny your application, if you are placed in removal proceedings, or if USCIS accuses you of fraud, you need an attorney. These are serious situations that require professional legal help. If you are unsure whether you are maintaining your green card properly, especially if you travel frequently or spend time outside the US, a consultation with an immigration attorney can give you peace of mind. Many attorneys offer initial consultations for a reasonable fee, and it is worth the investment to make sure you are doing everything correctly. Let me give you some context about what is happening more broadly with immigration processing right now, because I think this helps put everything in perspective. USCIS is currently experiencing some of the longest processing times in recent history. Family-based green card applications can take anywhere from 1 to 3 years, or even longer depending on your category and country of origin. Employment-based green cards have similar delays, and some categories have backlogs that stretch for years due to annual visa caps. Naturalization applications, the process of becoming a U.S. citizen, are taking anywhere from 8 months to over 2 years in some locations. These delays are caused by a combination of factors including increased application volume, staffing shortages at USCIS, pandemic-related backlogs, and policy changes that require additional review steps for certain cases. None of this means the system is broken beyond repair. It means the system is slow and overburdened. For those of you waiting, I know this is incredibly frustrating. You have done everything right. You have submitted your applications, paid your fees, attended your interviews if requested, and now you are simply waiting. This waiting period is one of the most stressful parts of the immigration process, and I want you to know that what you are feeling is completely normal and completely valid. Many of you are also dealing with the uncertainty of not hearing anything from USCIS for months at a time. You check your case status online, and it shows the same update it showed 6 months ago. You call the USCIS contact center, and they tell you your case is still pending. This silence does not mean something is wrong. In most cases, it simply means your application is sitting in a queue waiting to be reviewed. USCIS processes applications in the order they are received for the most part, and when there are millions of applications in the system, each one takes time. If your case has been pending for longer than the normal processing time posted on the USCIS website, you can submit an inquiry through their online system or through your congressional representative's office. Sometimes this can help move things along, but often it just confirms that your case is still waiting to be processed. For those of you with upcoming interviews, whether for a green card or for naturalization, preparation is key. Review your application carefully before your interview. Make sure you remember what you wrote and that you can answer questions about it honestly and accurately. Bring all requested documents with you, and bring originals plus copies. Dress neatly and professionally. Be polite and respectful to the officer. Answer questions clearly and truthfully. If you do not understand a question, it is okay to ask the officer to repeat it or explain it. If you do not know the answer to something, it is better to say you do not know than to guess. The interview is not designed to trick you. It is designed to verify the information in your application and to make sure you meet the requirements for the benefit you are seeking. For those of you who are waiting to travel, whether internationally or even just considering it, understand that traveling while your application is pending can sometimes cause delays. If you are waiting for your green card and you have filed for adjustment of status, you generally should not travel outside the U.S. without first getting advance parole, which is permission to re-enter. If you leave without it, your application could be considered abandoned. If you already have a green card and you are applying for naturalization, you can travel, but make sure you return before your interview date and make sure your trips are not so long that they raise questions about whether you are actually living in the United States. If you have to travel for an emergency, document the reason and keep records. Immigration officers understand that life happens, but they need to see that you are being honest and that you are maintaining your ties to the United States. Now I want to take a moment to speak directly to the emotional side of this experience, because I know that going through the immigration process is not just a legal or administrative journey, it is deeply personal. It affects your sense of security, your plans for the future, your family, and your peace of mind. Many of you are living in a state of uncertainty, not knowing when you will get an answer, not knowing if everything will work out the way you hope. You may feel anxious when you see news about immigration policy. You may feel frustrated when you see others getting approved while you are still waiting. You may feel isolated because the people around you who were born here do not fully understand what it is like to have your entire future dependent on a government decision. I want you to know that these feelings are valid. You are not overreacting. This is genuinely hard, and it is okay to acknowledge that. You are not alone in this. There are millions of people going through the same process you are going through right now. There are families waiting for approval, workers waiting for their green cards, students hoping to stay after graduation, and spouses waiting to be reunited with their loved ones. The waiting does not mean you are forgotten. The stress you feel does not mean you are weak. It means you care deeply about your future and the future of the people you love. Give yourself permission to feel what you are feeling, and also give yourself permission to take breaks from constantly checking your case status or reading every piece of immigration news. Sometimes the healthiest thing you can do is step back, trust that you have done everything you can, and focus on living your life while you wait. If you are supporting someone who is going through this process, whether it is a spouse, a parent, a child, or a friend, please be patient with them. Understand that even small delays or pieces of bad news can feel overwhelming. Listen to them. Reassure them. Help them keep perspective when things feel hopeless. Your support matters more than you know. Let me now bring everything together and summarize what you truly need to know. The confirmed changes to green card policies this year are real, but they are not as dramatic or as threatening as some headlines make them sound. These changes involve procedural updates, fee adjustments, processing modifications, and shifts in enforcement priorities. For the vast majority of green card holders and applicants who have been honest, who have followed the rules, and who are meeting the basic requirements of their status, these changes will not negatively impact your life. The immigration system in the United States is structured, it is legal, and it is slow. It is not random, and it is not designed to trap people who are doing the right thing. Yes, there are rare cases where serious problems arise, but those cases involve significant issues like fraud or serious criminal activity, and even then, they go through a legal process that includes the right to defend yourself. Your green card, if you obtained it legally, is not something that can be taken away on a whim. Your status is protected by law. If USCIS ever has concerns about your case, you will be notified in writing, you will be given an opportunity to respond, and you will have the right to seek legal help. The system is not perfect, and it is certainly slow and frustrating right now, but it is also predictable in many ways. If you follow the rules, keep your documents in order, respond to any requests from USCIS, and maintain your residence in the United States, you are doing what you need to do. Do not let fear control your decisions. Do not let rumors and misinformation make you feel like you need to take drastic action. Stay informed, yes. Be aware of changes, yes. But also trust in the strength of the legal immigration system and in your own ability to navigate it. You have already come so far. You have already overcome so many challenges to get to where you are today. Do not lose confidence now. If you found this video helpful, I invite you to stay informed by subscribing to this channel. I will continue to bring you updates on immigration news, always with the same goal: to give you clear, honest, calm information that helps you understand what is really happening. If you have questions, or if there are topics you would like me to cover in future videos, please feel free to leave a comment below. I read them, and I genuinely appreciate hearing from you. Your experiences and your concerns guide the content I create. Thank you so much for watching today. Thank you for trusting me with your time and your attention. I know that information about immigration can feel overwhelming, and I am honored that you chose to spend these minutes with me. Remember, you are not alone in this journey. Millions of people are walking the same path, and most of them are moving forward successfully, even if slowly. Take a deep breath, stay informed, stay calm, and keep moving forward. You are going to be okay.